Good afternoon. Hi there. My name's David Hackett, Head of Client Management here at the DPS. Thank you so much for joining today's webinar where we'll be talking about the Renters' Rights Act. I am joined today by Susie Crolla, the Managing Director of the Guild of Letting and Management. Good afternoon, Susie. How are you?
Good afternoon, David. I'm very well, thank you. Looking forward to this.
Good. Thank you so much for joining today. I know it's a topic that has been hotly discussed in great detail by many people. Today you'll be doing a strategic overview for us, which is fab. I know me personally, having the pleasure of knowing you for many years, Susie, I know I learned something new every time I speak to you. So again, thank you so much for joining. We did get a lot of questions come in ahead of today's session. Those questions, looking through the information provided, I'm sure a lot of it will be covered off. But I know you kindly put together a set of FAQs for us, which we'll touch on at the end of today's session. So thank you so much. All that's left for me to do at the start of the session is pass over to you and your font of knowledge, Susie. So I shall pass over and catch up with you at the end. But thank you again for everybody for joining, and thank you. Over to you, Susie.
Thank you, David. Thank you for that introduction. So good afternoon, everyone. You should be able to see my lead slide, effectively what we're going to be talking about today. This is a topic that, unless you have transferred yourself to Mars, that you should have heard of. So we've been looking at this for a while, and prior to the Renters' Rights Act, we had the Renters Reform Bill under the previous government. So a lot has changed over the last few months. So what we're going to do, I'm going to walk you through as best I can, pretty much in terms of the time frame and the time frames that you have to work to in order to ensure that you and your landlords and your properties will be compliant. So effectively, what I've put on screen is just an objective that I really want you to think about this in a very positive light. There has been a lot of negative press around this, obviously not just the Renters' Rights Act or the bill as it was, but also the Renters Reform Bill since 2019. So there's a lot of headlines that kind of have caused havoc, in my opinion. So I want to focus on the detail. I want to focus on what you will have to do to make sure that you are compliant, that we focus on both landlord and tenant obligations, and that we think about your business. Obviously, if you're a landlord or an agent, we're thinking about your business and making sure that you are very much ready. So I'm very much a practical learner. It makes me smile. I have to do a lot of reading, and I like to break things down into very manageable sections. So we're going to focus on what's on screen. On the left-hand side, you have elements that you will have come across. In fact, everything on this slide you will have heard of. So ending the assured short-hold tenancies and the assured tenancies and replacing them with assured periodic tenancies. Now that is extremely significant. And one of those questions that springs to mind is how? Or alongside that, in abolishing Section 21, and again, this had to be the lead headline way back in 2019, that Section 21 would be abolished. You know, this reference to no fault eviction. And something that I really want to clarify here is that serving notice is not an eviction notice, and it never has been. And moving forward, when the Section 21 is abolished, it will be replaced by an existing but updated version of Section 8. And that is not an eviction notice either. Okay, so we're kind of moving towards something very different. In a way, a streamlined method of obtaining possession rather than having two options. So the Section 8 will be the go-to. On top of the Section 8, we have another increasingly important notice. Now, a lot of clients that we work with whether they are landlords or letting agents, sometimes don't use Section 13s. They use the fixed term tenancy, they rely on the rent increase clause, and so forth. Therefore, there's no need to rely on the Section 13. Moving forward from a particular date in the future, the landlord will only be able to rely on Section 13 as the vehicle to increase rent. And then sitting around that, there'll be some other elements that we need to think about in relation to the rent increase itself. Is it percentages, CPI, RPI? So we need to make sure that we adhere to what the legislation is saying. And then frequency, notice periods. So there's a lot around the rent, advance rent, making sure that the landlord and the agent don't encourage bidding wars where one tenant pitches against another, and those kinds of things. Things that have never been embedded in law before. So that's really, really important. A topic underneath that is one that I believe, as much as I am very much a pet lover, there's a lot of energy been spent on this one, and rightly or wrongly, a little bit more energy could have been spent on other elements of the Renters' Rights Act. But regardless, this was a headline, blanket ban on landlords refusing pets. That's not true. Okay, landlords will have the right to refuse a pet in the way that tenants will have the right to request a pet. Okay, so they're two different things, and very much the detail is very, very different to the headlines, you know, throughout the whole of the press, across the whole of England when, you know, this was announced. On the opposite side, discrimination. Now, obviously, discrimination and discriminatory practices are most definitely frowned upon, but we've never had this particular area cemented in law. So this will relate to what will be known as rental discrimination. Okay, some phrases that we've never come across before, and that's one of them. And that will be in relation to applicants who are in receipt of benefits and applicants who are families. Okay, so they have children. So that's something that we need to think about very, very carefully. Now, alongside that, we have two elements that, when we start looking at the timeframes, will be delayed. They're not going to happen immediately. So the introduction of the private rented sector landlord ombudsman is not going to happen straight away. So that's something that you need to think about very carefully. And alongside that, and this topic, this element of the Renters' Rights Act has been discussed at length for so many different reasons, and that's the private rented sector database. Okay, so we have a different time frame for both of those elements of the legislation. And then finally, right at the bottom, we have Decent Home Standard and Awaab's law, also delayed into phase 3. Okay, so we're working on phases. Now, I'm actually going to start on the enforcement powers. Okay, so we're going to look at the enforcement powers because they sit within 2025, okay, for local authorities. Before we actually begin and we look at the detail, I just want you to remember that this happened relatively quickly. People will say to you, no, it didn't. It actually did. What we had before, the Renters Reform Bill, a lot of the groundwork was actually covered by the Conservatives. This is, I would say, in my opinion, and this is not a legal opinion, it's a personal opinion from what I've read and looked at and studied, is that this is a much tougher version. Okay, but we have to work with what we've been given, and so my premise is to be ready. Okay, so we already have 24 guides. There are 24 guides that have been published so far. Those guides are available on the .gov.uk website. So guides about if the tenant requests a pet, guides about service of notice by the landlord and by the tenant. So the guides are there, but something that I really want to make very, very clear is if you are looking at these guides, save them into a favorites folder so that when they are updated, you will get the correct version. Okay, so that's really, really important. One of the things I want you to bear in mind is the volume of information, 226 pages. That's not the biggest piece of legislation. That sits with the Companies Act, but it's significant. Somebody has to read all of this. Okay, so the stakeholders, lawyers, barristers, legal firms, the Law Commission, okay, and that's just from the legal point of view, judges, the courts, and so it goes on. And then practitioners, letting agents, and it just goes on and on and on. So we need good, clear, accurate information, okay? Because there are a lot of things out there that maybe aren't particularly correct. So the roadmap is what the government has called this. And basically it's a timeline. And you can see right at the very top on my right-hand side that you have royal assent. Okay, so 27th of October, the bill became an act, and nothing really major changed on that day, but we were waiting for further announcements, and those further announcements came along in the form of guides. Okay, so the government, and this is probably sits with the civil servants, I would say, is what I actually like about this is the phased approach. Okay, so I'm going to be talking to you predominantly about phase one. And that's not the most challenging, but there's a lot of work to be done. And then there'll be phase two and then phase three. Okay, so we're working on timelines. As you can see in November, and obviously we're now in December, a lot of guides have gone out, a lot of information, and the government are really very much thinking about their comms. How do they communicate this to stakeholders? You know, for example, like you. How do they communicate to tenants, landlords? Remember, there are on average 2.4 million landlords, some of whom are DIY landlords, don't belong to any organisation, don't use agents, maybe accidental landlords. So there's a lot of information out there, and that is really, really important. Now, on top of this, we go to December, which is very bizarre, and I've been training on this pretty much all week. And somebody said to me on Tuesday, Susie, did you know that 27th of December is a Sunday? And no, I didn't actually, but it doesn't really surprise me. So we're going to talk about the enforcement powers that come into force on a Sunday in the middle of the Christmas festivities. Okay, so that's going to be really, really important. Just on dates, our first phase begins on the 1st of May. Okay, so that effectively is what we're going to talk about when we've talked about enforcement. Then we move forward to April 2026, communication campaign and guidance notes for tenants, which, you know, is incredibly important because remember, you know, this is about landlord-tenant relationships. So we want tenants to be aware of things that they have to do. Okay, so there are things that the tenant will be obliged to do. Service of notice, for example, requesting a pet in writing. So there are things within the legislation that put the onus on the tenant that they have to deal with. Okay, so that's very important. And then our first big key date, 1st of May 2026, and that will be phase one. Okay, so we'll be working through most of that in the next 45 minutes. Late 2026 came as a surprise to a lot of people is the database. Now, in a way, I feel quite comfortable that the government has decided to delay the introduction of the database because there's so much going on. And that means that there will be a pilot probably running, I've read, across the Midlands. And so It may start there and then be rolled out further across the whole country into 2027, which I think is a good thing. Okay, so that's very, very important. Then we go into 2028, which again has surprised a lot of people. And this is the mandatory membership for all landlords in England, regardless of landlord type, regardless of whether they are an individual, a trust, a limited company. They all have to be registered on the database. So equally, they have to be members of the Landlord Ombudsman Service. And there's a lot of discussion in the background about how this Ombudsman Service will run, who will assist, who will set up, and who will administer. Okay, so that's extremely important. And then right at the very bottom, Decent Home Standard and Awaab's Law. Okay, so Decent Home Standard has already been in consultation twice, and Awaab's Law has been introduced into social housing on the 27th of October. So if you're interested, you can read the guidance. It's actually worthwhile. But for us, there will be a delay, okay, for lots of different reasons. So we have a poll question here, and I put these things in, and I think this is really important, and I should be able to see what the results are, but forgive me if I'm not quick. So landlords will not be fined for an initial breach, and that's the first breach of the Renters' Rights Act, true or false? So those of you that would be happy to answer, that would be great to see. I've actually answered as well, and we have a really good result, and that makes me so happy. It's sitting, well, actually, it was 74%, and then now it's come down to 64%. It's actually false. Landlords and agents will be fined for an initial first offence. So that is really, really important to be aware of. Now, why did I lead with that poll? Very simple poll. Because I want to talk to you about enforcement. Generally, I do not start training sessions. We don't start our training sessions with enforcement. But this is so important, and I'm sure that as a result of this, there'll be a lot of questions. There is guidance on the .gov.uk website. The government is giving all local authorities in England from the 27th of December the power to, based on an investigation or a suspicion of a breach in relation to housing, and we're talking about private rented, the ability to request information, but also to gain access, okay, to a property, or come into an agency and request that information. Now, there is a notice that the local authority must adhere to, so they cannot just appear and ask you for all your files. They will have to adhere to section 114 of the Renters' Rights Act, and they have to tell you what they need from you. The notice has to be in writing. They have to tell you the consequences of not providing the information. They must tell you the specific date by which the information is required. So let's say, for argument's sake, within 14 days, calendar days, and the format that they want this information in. Now, I'm not expecting local authorities to ask a letting agent to provide all their files, hard copy, put them into a van and take them to the local authority's office. I hope that would never happen, but they could ask for files. So if I just give you an example, it could, this investigation could be related to an HMO property. Okay, so the tenant has contacted the local authority. There is an investigation, so the local authority will be asking for information. Tenancy agreements, safety certificates, fire risk assessment, the application form for the HMO license itself, who completed it, payment, proof of payment. So a whole raft of information. And that is really, really important. And that information will be sent to a specific person. Obviously, the information will be on that notice, and there will be a legal requirement to comply. Now, adding another layer to this, the local authority can come, as I said, to an agent's office and request that information as well, and also go to the property as well. So that's really, really important. And we've never had this kind of situation before. Obviously, we have enforcement through trading standards, local authorities, environmental health officers, but not in this way. Okay, so one thing that I would say, and obviously I'm limited for time, is to start looking at your portfolio. If you are a landlord, check that everything is as it should be, and the same with agents. So for agents, it may probably be easier because you have a software system. You can run off a report for all the gas safeties across the whole of the portfolio, and you can see if there's anything that is strikingly concerning. Okay, the same applies to the condition of the property, and so on and so on. Okay, so that's really, really, really important. On top of this, there are the penalties for non-compliance. Now, the penalties under the Renters' Rights Act, these new penalties, they come into force on the 1st of May 2026. So any investigation that happens from the 27th of December 2025 to the 30th of April 2026, penalties will sit under existing legislation. It's just the enforcement element and their powers and the investigations they're permitted to do that will be different. But from the 1st of May, the penalty structure changes. So we have a first offence, which is why that true and false poll was so important. First offence of up to 7,000. And remember, landlord or agent or both. And then subsequent more serious offences of up to 40,000. Okay. Now, for me, that is, more than enough. But if this were a very, very unpleasant tasting cake, we have another layer on top. And that further layer is the rent repayment order. My view is, if I'm concerned about the legislation and I need to protect my portfolio, and I don't think that I can navigate all of this, I'm going to find myself a really, really, really good agent, because my agent will protect me and minimize the risk. Okay, the rent repayment orders are moving from the current threshold of up to 12 months rent repayment awarded to a tenant, and they're moving up to 24 months. And the tenant then has 24 months to pursue the landlord or the agent. This page, this slide, is not for the faint-hearted. So my premise is minimize risk, systems, processes, implement change. Okay, so this is probably one of the most important slides that you will see, because I don't particularly want to face anything on that slide. Okay, so this is extremely key. So I work in a color-coded way. Everything in pink will relate to paperwork. And obviously, I've mentioned very, very briefly at the beginning of this session that there will be no more assured tenancies, those tenancies that began in 88, right the way through over a kind of an 8 and a bit year period, ended in 97, then to be replaced by assured short-hold tenancies. So it's those two categories of tenancy that will no longer be used. Okay, so they effectively disappear on the 1st of May 2026. So what do we have in its place? A person said to me yesterday, there will be no contract. Well, there will be a contract. Two things we need to think about. The first thing for me, especially if I've got a really big portfolio, is my existing tenancies. So my existing tenancies from the 1st of May up to and including the 31st of May, I need to issue all my tenants, and I said that deliberately slowly, with what is known, and we haven't seen this yet because there's no guidance and it hasn't been published, a written statement of information. Okay, so we will have a window. It starts on the 1st of May, ends on the 31st of May, which people keep telling me the dates, it's a Sunday, but factor in, this is very important, 2 bank holidays and some weekends within May. Okay, so we need to be really, really diligent because this is time sensitive. We can't leave it until June. Okay, so the guidance for the written statement will be published in January 2026, and the written statement can be downloaded as a government template from the .gov.uk website. And just for clarity, when a form is issued by the government, we complete it. We don't do anything else with it. Okay, we need to be certain that we don't take wording and we don't take logos off, or we just need to make sure we use the template. On top of that, we've dealt with our 1st of May process moving forward and issuing the written statement. What about our new tenancies? So we have tenancies starting 1st of May, 2nd of May, 3rd, 1st of June, all in 2026. Those tenants will receive a new assured periodic tenancy. Okay, so you're going to have to familiarize yourselves in advance. And, you know, I'm very, very clear on this. Some things are non-negotiable. 2 of the things that are non-negotiable is read the written statement and read the assured periodic tenancy. If you have 15 staff, everybody reads it, and it could be together. Okay, so you go through this kind of training process to familiarize yourselves with the assured periodic tenancy. Why? Because some elements that exist now, right up to and including the 30th of April, will no longer exist. I'll give you an example. Break clauses, no longer relevant. End date of the tenancy, no longer relevant. Okay, so we need to kind of get used to this new paperwork. And effectively from January, we will have about 20 weeks, hopefully, to get our head round what this will look like. Also on that date, no more Section 21. But if you have served a Section 21 at any time, let's say between now and nearing the 30th of April 2026, that's fine, but it's applying to the courts that is going to be time sensitive. So why is that going to be important? Because there will be a cut-off for the landlord to apply to the courts, and that date is the 31st of July, and that's for pre-existing notices, both Section 8 and Section 21. The landlord will have had to apply to the courts by end of business on that day. Okay, so what that tells me is that you really need to think very carefully, if you are an agent, if you are a landlord, about when your cut-off is about serving Section 21s, existing Section 21s and Section 8s into 2026. Okay, so some of our clients have said they will not serve Section 8s or Section 21s tail end, early part of April, or they will advise their landlords that they need to use a solicitor. Why? We cannot afford mistakes because we have nowhere to go if there's an error. Okay, so we need to be very clear about that. What replaces the Section 21 and its Section 8? And there is a huge amount of discussion around Section 8, predominantly around ground 1, landlord moving back in, or landlord's relative moving back into the rental property, and then ground 1A, which we've not experienced before, the ground for sale. And you'll have read in the press that, and this is a few years ago, landlords will never be able to sell, the housing market will collapse. That's not true. Okay, what the press hasn't done is they haven't told you the truth. They haven't told us the detail. Okay, we've had to wait until now to find out what that is. And of course, landlords can move in. And of course, landlords can sell. But there will be restrictions. Okay, so that is really, really important. And I've seen the Q&As that have come through and they've been amazing. And what we've done is we've put together the answers, and I think David will mention right at the very end where you can access that information. Now, something I do want to stress is that that information provided on any of those questions does not denote legal advice and may be current today, but maybe in January the guidance may have changed. Okay, so look at the information. That sounds like a moot point, but we need to make sure that you are covered and very comfortable about that. Everything in green is to do with rent. So section 13.2, that is going to be our vehicle, our mechanism, not an email, not a discussion, not a telephone conversation. Okay, so formal notice, giving the tenant 2 months notice in line with a rent date or anniversary date. And that's important because some of our clients, some agents, some landlords, the tenant moves in on the 15th of the month and the rent date is moved to the 1st. Okay, so we'd be going by the 1st, not the 15th. But if those two dates are the same, all on the 15th, then we serve notice in line with the 15th. 2 months notice. So we need to be preparing in advance. You need to prepare, I would say, for rent increases, most definitely 3 months in advance, to have a discussion, to talk to the tenant, to talk to the landlord, to put your information together, okay, because you need to be working in line with market rent, okay, and that is really important. So you've got a lot of information, more than I have, because I'm not a letting agent. I don't deal with these kinds of things on a daily basis. They're the valuers, the negotiators, and so on. So they know where to look, and we need to make sure that this is calculated correctly. We also need to think about rent in advance, rental bidding. Now, rental bidding, I don't actually personally see very often, but our clients tell us that it does happen, depending on where you are in the country, depending on supply and demand, depending on the quality of the property. Lots of reasons. Okay, so that will be unlawful, alongside accepting a higher offer than the advertised rent. And I'm hearing lots of things that I don't really want to pay attention to about how people are going to circumnavigate this. So if the rent is advertised at £1,000 per calendar month, 3 offers come in, the first at 1,200, the second 13, the third at 14, that's going to be a problem. Okay, so we need to think about this really carefully. And then the rent in advance. The rent in advance will be time sensitive. So contracts signed first, our assured periodic tenancy, signature from the tenant, signature from the landlord. The tenant then pays their 1 month's rent in advance. Okay, so it cannot work back to front. If the tenant pays more money, that has to go back. Okay, so that's really important. But there will be an opportunity if the tenant offers and is not coerced, is not forced, is not manipulated, the suggestion doesn't come from the landlord or from the agent. If they're willing, and this is pre-contract, for lots of different reasons, to pay rent in advance, that payment has to happen after they've moved in. And that will be documented in the contract. So that'll be a contractual agreement, okay, that sits outside the law, but you wouldn't be able to deal with that in terms of taking monies in advance before contracts are signed and before the tenant is granted possession. Now, one of the big bugbears around all of this in terms of rent is, what do we do when the tenant challenges? And the tenant has to challenge, if they intend to, within that 2 month window. Okay, so we issue the section 13, we issue it in good time, we serve it correctly, there are no problems. The tenant has a 2 month window to challenge via the first tier tribunal. So I really do stress, and you're specialists in this, not me, is that you have discussions with the tenants. Okay, one of the questions that was in the Q&A information that was submitted was about, can we have discussions with the tenant? Absolutely. Okay, because then you know where the land lies. You will know better than anyone if the landlord is being unreasonable and if the tenant has concerns. Okay, so, you know, use your powers of negotiation and discussion. Now, the tenant's right to request a pet, how do we work around that? The request has to be put in writing, and we'll deal with that shortly and what that looks like and what landlords can and can't do. And then on top of that, we have in orange rental discrimination, and there's some new elements around that as well that I will make you aware of. So we have another poll question that I can see. The advertised rent, and I think I've tipped you off on this one. The advertised rent is $1,300. So which offer can be accepted lawfully? Okay, and look at the wording. So we have the Japanese student offering 24 months rent in advance, single parent, 3 children under the age of 10, $1,450, chartered surveyor, $1,350, or none of them lawfully. And I'd be interested to see the answer on this one. So we have 15% showing us, or 17 for A, hardly anyone with B, tiny percentage on C, but the majority at 73% correct answer is D, so none of them. Okay, now you'll have this landlord who insists. You'll make it very clear in advance as we move up to the 1st of May that depending on how A was worded, and I can see why people opted for 23% because of the word offering. It depends on when they offer and how. Okay, so the fact that they want to pay everything in advance is a no. Okay, so none of them. And that's really, really important, especially for those landlords that are very insistent that you follow their rules. We cannot break the law. Okay, so that's really key. Okay, so then we have implementation again. We have the tenant's requirement to serve notice. So this I like, this some people don't, some people do. Highly unlikely that every single tenant in England is going to serve notice on the first day that they move in. Okay, but you have existing tenants who will have the right, even on a fixed term tenancy now, that converts to an assured periodic on the 1st of May, has a break clause, is a 2-year contract, and the break clause is time sensitive. That will no longer be relevant. So as from the 1st of May, the tenant can serve 2 months notice, not at any time. Okay, so that's been something that's been discussed, not at any time, in line with the rent date, anniversary date. Okay, now again, we have something that we've never had in law before, and this is looking at Scotland. They've done something very similar, and this is the service of notice by joint tenant. So we have tenant A, B, and C. Tenant A serves notice, doesn't talk to B or C. They have to tell them. They have to tell tenant B and C notice has been served. How do we preempt this? Because our clients, you, are very, very good at this. You write back to all the named tenants and you confirm receipt of notice so that nobody is left in the dark. And then change of sharer and so on you deal with normally. So either A goes and we find not we, but they find a replacement, or they all leave. Okay, so that's something that you preempt in advance and deal with whatever the consequences are. Okay, so that's something very, very important. Now, the written statement, time sensitive, time frames. I've put this on, it's very simple, very simple. So where do I get my written statement from? What does it look like? What does it say? We don't know, but we've got a pretty good idea that the written statement will give an outline to all named tenants, 5 tenants on a joint contract, 1 written statement with all the named tenants, 1 copy to each. Okay, don't leave anyone out. Also to the guarantors, and obviously if you are managing the properties, you will deal with this on behalf of your landlords. Okay, so time frame starts on the 1st of May, ends on the 31st. Okay, we need to factor in public holidays. It's actually not a good month to do this. The other thing is delivery. How do we serve this? One thing that I would advise you to do is to look at your current contracts and look at method of service. You have to go based on the method of service in your current contract. If it's email, digital, makes it easier. If it's first class post with a certificate of posting, as the client that we were with yesterday, is in service of notice not via email, that's going to be very expensive. They felt quite comfortable with that, okay, but you need to think about these things. So if you're managed landlord, your agent is going to be dealing with this. There may be a cost, they may not. That's not up to me, that's up to the agents. But think about your let-only landlords. Your let-only landlords are going to have to do this within a time frame, and are they aware? Okay, so think about how you communicate this back to your landlords. Removal of Section 21, I have already referenced, but the reason I've put this slide on is because there is a lot of time sensitivity. Okay, so we can serve notice up to and including April 26, but then I've got a really, really tight time frame if the tenant doesn't vacate 2 months later, which is going to take me into early July, and then I need to issue court papers. So I really would be mindful about you taking control and advising your landlord that we have a very brief window from, I would say, end of March to end of July. We need to tie everything up by the 31st of July, and hopefully that's not a Sunday as well. But you know, if you're taking court papers, if you're going to issue court papers on a Section 21 or alternatively on a Section 8, you can't do that by post on the 31st of July, okay? Because you'd have run out of time, okay? So lawyers will look at this. There'll be a lot of challenges, but you really need to draw a line in the sand, okay? And that is really, really important. If someone contacts you on the 30th of April at 3:30, panicking, asking you to serve a Section 21, it's not going to happen. Okay, the cutoff is 4:30 by hand. If you actually have the ability to serve by hand in your contract, okay, so be really mindful of how this is going to work. Now, amendments to Section 8, exactly the same. I like Section 8. It's not personal preference. I just find them easier to navigate. I always have. They're a good deterrent. You would send a copy to the guarantor. The guarantor can then be listed as the second defendant. So more and more work is going to happen around Section 8. If you don't feel comfortable with Section 8, then obviously you need to make a decision. Do you outsource service? Do you keep service in-house? Just as you would now. But does your insurance, if you are an agent or a landlord, does your insurance cover you for the service of a Section 8? Because the consequences are not pleasant if we get this wrong. Okay, so again, even though Section 8s are valid for a whole 12 months from the date of service, in the future, there'll be a cut-off on the 31st of July for any notice served prior to the 1st of May. Okay, so again, think very carefully and have discussions with your landlords and so on. The significant changes, I will tell you, are being introduced, obviously, by the Renters' Rights Act. Notice periods. The majority of the grounds are going up to 4 months notice. So telling the tenant that certain things have to happen. And some of the grounds, especially on the discretionary, 9 to 18 are 2 weeks, but you need an awful lot of evidence to rely on those grounds. And then we have 2 grounds where the notice period is immediate, and that is ground 14 and 7. Now, I mentioned grounds 1 and 1A, and there's a lot of discussion around this. And we've written an article which we are going to publish on our website over the weekend, purely about grounds 1 and 1A. We'll send a copy to DPS, and obviously it's not legal advice, but it is guidance on how you navigate the ground 1 and 1A. Why the restrictions? The government thinks that landlords, those unscrupulous landlords, will just fictitiously pretend to move back into the property. Okay, and they're the scenarios we deal with on training. We tell everybody the scenario, the landlord didn't really move back in, pretended, and then that needs to be dealt with. Okay, so, you know, this is very, very important that we understand how we can navigate, especially grounds 1 and 1A, and use them properly as they're meant to be used. Okay, and what I've done is I've given you the restrictions for Section 8 and the notice periods and so on. Okay, so a lot of people have been talking about serving the Section 8 under grounds 1 and 1A for new tenancies. Can't be served in the first 8 months, that's correct. Serve on the first day of month 9 to expire just beyond month 12. Okay, so it's 8, see how many fingers I need, 8 plus 4, okay, and a bit for service. Okay, so think about that really carefully. Poll question: tenant challenges the rent increase. It takes the first tier tribunal 6 months to agree the rent increase. So will the rent increase be backdated? So I'll give you an example. The rent increase is due to begin on the 1st of November, but it takes the first tier tribunal until March 2027 to come to a decision. And we have a resounding, oh, it's changing. We have a resounding, oh, it's actually 64%, it's come down. No, it will not be backdated. Okay, the rent increase changing when the first tier tribunal says, yes, the rent increase is fine, doesn't change the rent increase date. So we go back around again to November, and then we increase the rent again. So that's what is concerning a lot of landlords out there, that tenants will use this as a delaying tactic or avoidance. So this is the rent increase process, and you know, I know that I'm up against the clock, and I'm doing my best to get through everything with a fine-tooth comb if I can. Obviously, Section 13, 2 months notice in line with the rent period anniversary date. Rent must be increased in line with market rent. Tenant has the right to challenge, which is entirely up to them. So I'm looking constantly at the test of reasonableness, you know, having discussions with my landlord, and then obviously no backdating. And that may change in the future. It really does depend. A little bit more about rent, which you've seen advertised and discussed and on every single webinar that you can think of, even publicised incorrectly in the Times by a journalist. The restriction, okay, the restriction on rent in advance. Now, how does it impact your tenants? How does it impact international students? There's something that really, really is very, very important. You've got to have discussions around this with the referencing companies, okay? Because what the government haven't done is really engaged with the referencing companies. Remember, the criteria for someone failing references doesn't sit with you because you're not a referencing company. It sits with a referencing company, okay? So this is really important. Advertise rent only, not above what's been advertised, and rental bidding, if it does happen in and around your location, will be unlawful. So our furry friends, lots of discussion about our furry friends. And again, I'd like to put some things to bed here. This works on both sides. The tenant has to give the landlord information about the pet. The landlord probably will know whether they'll accept pets or not. They'll know even before the question's been asked. But the landlord has to go through the process. If the tenant doesn't provide that information within the time frame within which the landlord needs to make the decision, the landlord says no. Okay, so we have put together a pet profile, which is probably the most fun document I've ever put together. And it asks lots of questions, and the tenant has to answer them. That then goes to the landlord makes a decision, and if it's yes, then we factor into the contract pet clauses, information about the pet, what the tenant has agreed to, and so on. If the landlord refuses, that refusal has to be put in writing, and the landlord will have a further 7 days to put that refusal in writing. And just so we're clear, the list is pretty interesting. Okay, so I've given you these beautiful animals, and I'm just going to use this as an example. If the tenant is renting a property with a 1/3 of an acre garden and asks for a llama that's not going to come into the house, then the landlord will make the decision based on information about the llama. Okay, but if it's a 1-bed flat and the tenant says, I'd like a llama, I think we all know the answer to that question. Okay, so these reasons have come from a lot of group work over the last 12 months, from the government guidance, and so on and so on. Okay, right at the top of my list probably is the bullet point right in the middle, restrictions in the head lease. Okay, most head leases are not silent on pets. They're not silent. It says restrictive covenant, no pets. Okay, so that's fine. But if the head lease is silent, then the landlord, leaseholder, has to go to the freeholder, superior landlord, and ask for consent. And the likelihood, I'm not definite, it possibly will be no. Okay, so there's some of our reasons. Discrimination, not acceptable, but there is a caveat to this. And again, for those of you that have read the guidance, and myself included, my focus here is the PMLA. And this is a proportionate means of achieving a legitimate aim. What does that mean? That counteracts discrimination. In what way? And I've given you a very clear example. It's refusal of children based on the fact that these are studio flats. Okay, studio flats. There are shared parts, common parts, and the landlord feels that the space is not good for children to be around because there are strangers, they can't deal with safeguarding and so on. So that would be a legitimate reason to refuse. It could be the fact that the property can't be modified. There's some hazards that can't be removed. We can't make reasonable adjustments. So think about this really carefully. So not every situation is no. Now, the private rented sector database, I've said, will appear tail end of 2026. A lot of work is going on around this, and it's in its kind of beta testing phase. Okay, lots of different organizations have seen the database. They're thinking, will it speak to your software? Will it make it easier for you? If you are managing the properties in the numbers, in the hundreds, thousands, make it easier for you to deal with this for your landlord. Okay, so every single landlord who is managed, rent collect, let only, must be registered on that database in order to advertise, market, let, and then one more thing, obtain possession of the property. If the property is not on the database, landlord will be in breach if they try to do any of those things. This is the information that we've gathered from the civil servants. So column 1 will not be visible. And this is really important. I am a big advocate of GDPR, data protection. Okay, and I would not be happy if my data were in the public domain. So that element will be probably for you with a new landlord to see whether the landlord is registered and has done everything correctly, most definitely local authorities, and most definitely HMRC, and maybe other organisations. The other 2 columns will be in the public domain. So there's nothing that is relatively sensitive. Probably the lender won't be, but I can obtain that information if I wanted to by doing a land reg search and paying. Okay, so there's an awful lot that needs to be done before the tail end of 2026. Private rented sector ombudsman, again, alongside a payment annually for the registration on the database, landlords will have to also pay to join the private rented sector landlord ombudsman service. But I just really want to stress, no figures have been given. I keep being told it's competitive, but I don't actually know what that means. And then finally, the Decent Home Standard. Now, I'm not going to dwell too much on this, but I do want to draw your attention to the most recent consultation, which you can find online. It finished, I think, on the 11th of September. And then alongside that, Awaab's law as well. And these slides will be made available for you to read, digest, look at. But there's a lot of work being done around this. Really very, very important. So again, we have how we would have to deal in the future with emergencies, and it will be very time sensitive. Okay, so we'll be working within time frames. Now, I have 2 more slides and I'm very much up against the clock. First thing is, be ready. You need a really, really good action plan. And some of the elements that I've given you, you can actually start looking at now. Discussions with your insurers, referencing companies, talking to the landlords, events, looking at the paperwork when it's released in January, guidance, especially for the assured periodic tenancy. You have a window of 20 weeks to start working through this. Attend training sessions, really important. Okay, and there is a lot of information out there. Some of it you have to pay for, some of it's free, but do some really good research. Think about your suppliers who provide support. DPS, obviously, in relation to what's going to happen with deposits, prescribed information, and so on. David and I have already had that discussion, referencing CRM, insurers, contractors, and most important of all, your team. Okay, because if there's one person from your team on this webinar, then whoever hasn't seen this needs to have a look at the recording. And I leave you with my parting mantra. Your ducks need to be in a row. Really important. Okay, so one thing I really want to stress, do not worry. Just make sure that you stay informed, stay up to date, and start working through this in a very methodical way. Remember that everything is not happening on the 1st of May. So there we are. That's everything from me.
Amazing, Susie. Thank you very, very much. A lot of ground covered there. I'm sure you could have spent days talking about that, let alone squeezing it into this hour. Well, from our perspective, I would just like to say a thank you to you, Susie, for coming along. Whilst this information isn't DPS guidance, the information doesn't belong to the DPS. We're very grateful for you coming along, giving the Guild of Letting and Management's view on the Renters' Rights Act. This will be available on demand. Susie spoke about training. So for your team, your friends, your family, colleagues in the sector, this will be on demand for you too. So make sure you share and watch that. We got a load of questions coming in ahead of the session. a lot of them which were covered, thankfully, Susie, but you've kindly also taken the time to review a lot of these, so we will have an FAQ section also. Now, anything to do with DPS, deposits, anything you need from ourselves, visit the DPS website or email business@depositprotection.com. If you would like to find out more about the Guild of Letting and Management, visit guildofletting.com or email or call the details provided. And a final reminder that this information is government legislation. The rental is changing. There is a lot of information, a lot of guidance where the government have advised of this. So you can visit the government website via the link below. So all that's left to say is, Susie, a massive thank you to take time out of your day today for us. Thank you everybody else for joining, and I'm sure we will hear from you again soon. Thanks ever so much.
Thank you.